a deputy speaker of parliament, while presiding, can be counted as part of quorum and can vote is very disappointing, but not surprising to some of us, because some of us expected it to go the way it has gone. And my position on this latest decision is that the decision by the Supreme Court to the effect that the deputy speaker can be counted as part of quorum for decision making and can vote while presiding is patently unconstitutional and flawed in logic. Again, it is an unholy intrusion upon the independence and functions of Parliament, which I think Parliament should resist. And I would want to, in very simple terms, explain why I say so. Number one, this decision is patently unconstitutional because Article 102 of the 1992 Constitution is very clear. It is so clear that even non-lawyers can appreciate what that law, that provision is about. And Article 102 says, I quote, "A quorum of Parliament, apart from the person presiding, shall be 1/3 of all the members of Parliament." So quorum is 1/3, and that 1/3 does not include the person presiding. And so if a deputy speaker is presiding, even though he is a member of Parliament, the 1992 Constitution says at Articles 102 that he is not supposed to be counted as part of quorum. And without quorum, Parliament cannot transact any business. Now, the Supreme Court and the Attorney General of Ghana says, we agree that the deputy speaker, while presiding, cannot be counted as part of quorum. Quorum for what? Quorum for Parliament to transact business. You can't be part of that, even though you are an MP and represent a constituency. But when it comes to Article 104, which is about decision, voting in Parliament, the Supreme Court says the deputy speaker can vote. So the deputy speaker, per Article 102, even though he's an MP and represents a constituency, cannot be counted as part of quorum. But when it comes to voting, the Constitution says he can be counted as part of quorum and actually be allowed to vote. This doesn't make sense. Because if you check Article 104, it says that except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of the majority of members present and voting, with at least half of all the members of Parliament present. And so if in 102, all the members of Parliament excludes the deputy speaker while he's presiding, then at 104, all the members of Parliament present must necessarily exclude the deputy speaker while he's presiding. And so I cannot for the life of me understand why the apex court of the land will say that, oh, when it comes to quorum for transacting business, the first deputy speaker is not part. He cannot be counted while he's presiding. Or a deputy speaker, not just the first. But when it comes to decision making, they say, oh, when it gets there, you can count him because he's an MP. That violates clearly the express provisions of Article 102 when it is read together with Article 104. And so this decision by the Supreme Court, in my opinion, is patently unconstitutional. Again, Article 110 of the Constitution is clear. Because this Constitution did not make provisions for the conduct of business in the House, in Parliament, the Constitution, the framers of the Constitution at Article 110 gave Parliament the power to make standing orders to regulate its own procedure. This is what Article 110 says. Subject to the provisions of this Constitution, Parliament may, by standing orders, regulate its own procedure. And Parliament formulated their own standing orders to regulate their own procedures. And Order 1093 says that a deputy speaker, while presiding, cannot retain his original vote. Then the Supreme Court says, no, Parliament, you can't say that that order is unconstitutional. What provision in this constitution does that standing order violate? Because the framers of the constitution has given the power for the making of regulations to govern the business of parliament, has given that power to parliament. Now, if those regulations violate the constitution, then the Supreme Court, in interpreting and enforcing the constitution, can declare it as unconstitutional and therefore null and void. But where is the inconsistency between Standing Order 1093 and this constitution? Which provision in this constitution says that a deputy speaker, while presiding, can be counted as part of quorum and vote? For which reason you can say that that standing order is inconsistent with the constitution and therefore null and void. There is no such provision. There is no such express provision here. And in fact, if you are supposed to read 102 and 104 together like I've done, you can see that the framers of the constitution never intended that the one presiding should be part of quorum or should be able to vote. So clearly what they have done is an attack on the independence of parliament. Because you must understand that the fundamental principle of our democracy, Randy, is the principle of separation of powers. Okay, and the principle of the political question doctrine, which per the case of Tufo versus Attorney General, the case of GBA versus Attorney General, the Supreme Court has decided is part of our jurisprudence. And that principle basically says that where the Constitution allocates a certain role or duty or function to an arm of government, the court should not intermeddle with that. The court should not poke its nose into that. And that is why in Tufo versus Attorney General, Justice Sowa said that the law and practice of Parliament is a distinct body of law unknown to the courts, and that it is not the duty of the courts to inquire into that. In that case, Justice Sowa said, Parliament is a master of its own rules. So Parliament says that we don't want the one presiding, who is supposed to be an umpire, a fair, just umpire, to be a referee and a player at the same time. Now the Supreme Court said, no, we will make your own rules and regulations for you. Your referee, the one presiding, can vote. He can be counted as part of quorum. He can be a judge in his own cause against the principles of natural justice. How can the Supreme Court do that? And so Parliament, I think, must stand up and assert its independence. I'm looking at the Speaker of Parliament. They are an independent arm of government. If the judiciary have overstepped their boundaries, like I believe the Supreme Court has done, the Right Honorable Speaker and the members of Parliament should assert their independence. They are not sacrosanct, they are not sovereign. If they act in contravention of the Constitution, the Supreme Court has the mandate to correct that. Okay? But if they are barely exercising an authority the Constitution has given them under Article 110, which is to make regulations, standing orders, to regulate their own proceedings, and those standing orders do not violate or contravene any provision of the Constitution, the Supreme Court has no business in poking its nose into that, in annulling that. The Supreme Court cannot run the affairs of Parliament or Parliament. All right. Now, apart from that, Doc,
in a minute.
Apart from that, you see, this whole decision is based on the notion that a first deputy speaker, while presiding, should be counted as part of quorum and be allowed to vote because he's a member of Parliament representing a constituency. And so if you deny him the right to be counted as part of quorum and the right to vote, then you are denying his constituents that right to participate in decision making. That argument is very flawed in logic. You know why? Because if it was the intention of the framers of the 1992 Constitution that an MP representing a constituency at all times should vote, then they would not have provided for Article 104 clause 5. And Article 104 clause 5 says that even though you are an MP and you are representing a constituency, if a matter comes before Parliament, say a contract, and you are a party to a contract with government of Ghana, or you are a partner to a firm which has a contract with the government of Ghana, and that contract comes before Parliament because you are conflicted in interest, you can't vote on that. So the Constitution has demonstrated clearly that an MP, even though he represents a constituency, can be disallowed from voting where there is conflict of interest. But in this case, the Supreme Court says that where a first deputy speaker is presiding like a judge, he has a right to recognize you when you rise to your feet, rule on point of orders and order. He is a judge. He has a right to determine what motion to admit and what motion not to admit, what amendments to admit and order. He, as that umpire, even though he's conflicted, should still participate in it, in the voting. Again, check Order 225. Why didn't the Supreme Court declare that too as unconstitutional? Because per Order 225, a chairman of a parliamentary committee, Randy, you know, does not have an original vote, even though he represents a constituency. So if this logic that, a deputy speaker is an MP, he represents a constituency, so at all times must vote. Why is it that Order 225 says that?
Order 225. I'm holding the standing order of parliament. Well,
yes.
Show me your Order 225.
Order, okay. I'll get the specific order.
There is no Order 225.
I'll get the specific order for you.
I'm referring
to the specific order that says that chairman of parliamentary committees, when I'm done, I'll pull that out for you, do not exercise an original vote. They only exercise a casting vote where there is a tie, or the phrase there is equality of votes at the committee level. Why is that the case? If at all times members of parliament must vote. And then finally, you check Order 90. As for that one, you can check. I'm very sure of that one. And it says that
you can make
the speaker shall not participate in debates on the floor. So the first deputy speaker, because if you check Order 1, which defines these terminologies, it says that anyone presiding is Mr. Speaker. That's Order 1. And Order 90 says Mr. Speaker shall not participate in debates. But the first deputy speakers are members of parliament and they represent constituencies. So why don't we allow them to be part of debates? Why don't we allow them to be part of quorum under 102? Because if they are representing constituencies and their constituencies should not be disenfranchised, then they should be allowed to debate. They should be allowed to be part of quorum under 102. And chairmen of committees should be allowed to exercise their votes, original votes, at the committee level, because they are. So this decision portends chaos for parliament, because I've spoken to some of our MPs and I get the sense that they are ready to stand up and assert the independence of parliament and reject this intrusion. And the NDC as a political party supports that. We are calling on all our rank and file, our supporters across the country, to stand with our members of parliament as they stand against this clear injustice and this unholy intrusion upon the functions and independence.
Let me take a view on
this decision. Is unacceptable. And finally, as a lawyer,
thank you very much.
5 seconds. Let me advise the judiciary. Let me just do that. 3 seconds, and then you can. Let me advise the judiciary that, you see, in 2020, we saw a very worrying report from the CDD, that is the 2020 Afrobarometer survey, that showed that 84% of Ghanaians perceive the judiciary to be biased. That is a perception. 84%.
Have you done the survey now?
And so we need to be careful.
The survey now?
My advice is that some of these decisions,
all right, Sammy. Okay.
All right. Yes, don't augur well. Okay.
All right. Thank you.
Thank you, Randy. For the integrity.
My submission will begin with, reference to survey that was done many years ago that Sami is conveniently making reference to.
Is that 2020? Is that 2020?
That's the latest Afrobarometer survey.
Have you made reference to one that was done the most recent?
Which one?
This particular. And when you are making reference to some of these reports,
John, you don't have much time.
But that is besides the point. But it's a worrying times for us as a country. One, a very major actor in our democratic setup, a political party, bastardizes a decision of the Supreme Court in a manner that the NDC, by some members of the minority, and Sami Jemfi, the spokesperson for the NDC, using all manner of words, bastardizing a judgment, an interpretation, the exercise of the original jurisdiction and mandate of the Supreme Court, which is to interpret the 1992 Constitution. You can criticize, but you don't bastardize it the way you've done. Now, Randy, the decision that has been taken, the interpretation provided by the Supreme Court, the unanimous decision granted by the Supreme Court, which all 7 justices empaneled for the decision voted in favor without a single one dissenting. Is a major step in consolidating further the gains we have had in our democracy.
Sorry,
as a matter of fact, there's no 225 anyway. But let's move on. It is a necessary clarity that has been provided, Randy. It is a necessary clarity that has been provided into a matter which ambiguity has been covered by the convenient numbers we've had in our parliament over the years. Because we have never, Randy, come to a point where parliament had been this tight between majority and minority, with just one vote separating. And so our minds had not been drawn to certain ambiguities that needed clarity. That, see, every point in time, you hear lawyers, you hear activists, raising the point that there are some specific aspects of the Constitution, that needs some further clarity, that needs review, and all that. And so when some of these interpretations come, they mean well for our democracy. They are not travesty of justice. They are not obstructing justice. They are not taking powers away from parliament. And it is not in any way undermining the separation of power system we practice in this country. It is in line with best practice internationally of parliamentary practice. We must go straight to the points that the contention, as was raised by Justice Abdullahi, and I referred to the third page of the daily graphic, and the paragraph that's on Justice Abdullahi's case, that on December 21, 2020, Mr. Abdullahi invoked the original jurisdiction of the Supreme Court to interpret the 1992 Constitution and asked the Supreme Court to declare the action of Mr. Osei in counting himself as part of a quorum as unconstitutional. He also further wanted the Supreme Court to declare the whole proceedings in Parliament on November 30th, 2021, which led to the passage of the 2022 budget as unconstitutional. Now, when you are stating the details of the judgment, I understand, will be made available tomorrow. But looking at the substance of the decision, there are two kinds of quorum that is practiced in Parliament. And the quorum that is practiced in Article 102 is entirely different from the article, the quorum that is provided for under Article 104. And the two must never at any time be construed as same. Article 102 quorum is a quorum for sitting of Parliament, for commencement of Parliament. A quorum of Parliament, apart from the person presiding, shall be 1/3 of all the members present in Parliament. Now, the numbers that Parliament ought to have in the exercise of its decisions even vary from situation from situation to situation.
It's not all members present in Parliament.
Please, I quoted well, so please pay attention. Article 102. A quorum of Parliament, apart from the person presiding, shall be 1/3 of all members
of Parliament.
Not
present
to be able to. I didn't add that. So
no, you said present. Don't accept a harmless correction.
A quorum, for the purpose, for the avoidance of that, a quorum of Parliament, apart from the person presiding, shall be 1/3 of all members of Parliament.
Yes, that's correct.
That is a quorum required for commencement of Parliament business. Now, the quorum provided for under Article 104(1) is, except as otherwise provided in this Constitution, matters in Parliament shall be determined by the vote of the majority of members present and voting, which at least half of all members of Parliament present. So that is a quorum that is required for decisions to be determined. That is the quorum that is required to carry out decisions of Parliament, to determine matters in Parliament, which is an entirely different quorum from the one provided for in Article 102.
If you don't say
now, we need to go
on the matter of separation.
Our time is up. We've exceeded our time by 5 minutes.
Yes, but let me just conclude on the hierarchy of law. Article 11, just to conclude on that. People thinking that this interpretation is undermining our Constitution. That is not. It is the hierarchy of many law where the Constitution of Ghana is consistent with the Constitution.
There is no
enactment
inconsistency
made by
Article
or
11
under the authority of the parliament
Standing orders
established by this
are
constitution.
very correct.
Any orders, rules, and regulations made by any person or authority under a power conferred by this constitution, that is subsidiary legislation. Then the existing law and the common law. So it is in that.
So which constitutional provision does the standing order
contravene?
Yes.
So the interpretation of Article 102 and Article 104 takes precedence over standing order.
Which constitutional provision does the standing order violate or breach? Which constitutional provision?
Standing order.
The standing order 1093.
Yeah, which constitutional provision does it breach?
Which states?
Yes.
Which states that?
I can tell you.
Yes. Oh no. I just want to quote.
Which constitutional provision does it
I
breach?
just want to quote. We don't have order 1093. We don't have order 225.
As correct as it is 2115.
Now, the deputy speaker or any other member presiding shall not retain.
No, we know that standing order. I said which constitutional provision does it breach? Which constitutional provision does this standing order breach?
The interpretation of 102 and 104.
It breaches interpretation.
Nullifies the standing order.
We need to go.